We are starting with a very important topic of Indian polity, and that is the features borrowed by Indian constitution. So as we all know that the process of making the Indian constitution was a really long process, and we also have one of the most bulkiest constitution. So it is quite obvious that the time frame in which the Indian constitution came into being, there were already a lot of democracies emerging in the different parts of the world. So Indian constitution had borrowed a lot of its provisions from the constitutions of various other countries and states, like we can see in here in the list, and we have modified it according to our own needs and added to our own constitution, right? So we will be reading about the features that we have borrowed from different British parliamentary acts that have occurred in India, like Government of India Act. It was the major source of a lot of documentation because the Government of India Act of 1937 itself was a very bulky document, and we have borrowed a lot of features from there, but also from the British Constitution, US Constitution, Irish Constitution, Canadian Constitution, Australian Constitution, Germany's constitutions, that is Weimar Constitution of Germany, and the Soviet Constitution, which was then USSR, and now it's Germany, the French Constitution, the South African Constitution, and also the Japanese Constitution. All right, so we will be proceeding further now. First, let's start off with the Government of India Act of 1935. So the first thing that we borrowed from there is the federal scheme. Now the word federalism, the word federal comes from the word federalism, right? What does it mean? It means that the government, the power of the government is being distributed in different tiers, right? From center to states and then also to local bodies, right? That essentially is the federal scheme of India. And then we have borrowed the office of governor. We know that every state has a governor appointed by the central government. This office of governor, who is essentially the member of the executive but also have certain legislative powers. The governor is not directly a part of the legislative assembly of the state, but he is an official appointed by the central government, right? Then we see that another thing that we have borrowed from the Government of India Act of 1935 is judiciary, the judicial system, that is the Supreme Court, then the High Court, and then the subordinate courts. The whole system of judiciary, that is also taken from the Government of India Act of 1935. So the question for the day is, can you tell me when was the Supreme Court of India built in our country? What was the timeline? Which was the year when it was established? Okay, next thing that we have taken from Government of India Act is public commissions. Can you name a few public commissions? There is Election Commission, there is National Commission for SCs and STs. All right, so there are several commissions, several bodies that look into the several aspects of the Indian governance, right? They are formed to ensure proper governance of the country. So this concept of public commission has come into being from the Act of Government of India Act of 1935. Emergency provision. We know that there are three types of emergencies in our country, right? There is national emergency, there is economic emergency, and there is also state emergency, right? So we have three types of emergency, that is national, state, and economic. All right, so this emergency provisions and the administrative details of such have been taken from the Government of India Act of 1935. So let's just quickly go through all of them. Federal scheme, office of governor, judiciary, public commission, and emergency provisions and administrative details. The next is the British Constitution, because because Britishers were the one who got to rule in India for a long period of time, and it was initially East India Company, and then India came under the sovereignty of the British Crown. So we see that there are a lot of similarities between the British Constitution and the Indian Constitution, and we know the reason why, right? The first thing is the parliamentary government. What does the parliamentary government mean? Parliamentary government is the form of government where the executive is answerable to the legislature. So this creates the check and balance in our country, right? So the parliamentary government is taken from the British Constitution. Rule of law. There is a set of rules in the country, and the governance is done in respect of the rule of law, right? There is legislative procedure. The procedure by which the policies and the acts. Yes, so the policies and the acts that came into being from the legislature, this whole procedure is also from the British Constitution. Obviously it has been customized to the requirements of the Indians, and the provisions that have come into being in the constitution, to the bare bones of it have been customized to our own requirements, right? The concept of single citizenship. What is single citizenship? In our country, we are the citizens of India. We cannot acquire the citizenship of any other country. If we do so, then our Indian citizenship will be lost. And there is also no specific citizenship of the states that we belong from. Like if you belong from, say, Maharashtra or Gujarat or Karnataka or Goa, there is no citizenship based on the states that you reside in, but only one citizenship, that is, we all are Indian citizens. All right. Then there is cabinet system. What is the cabinet system? Cabinet system means there is a small grouping, right? There is a small group of the ministers who come together and form the cabinet. This is a unit that looks into the execution, that looks into the executions of the policies and the acts that is formed by the government. They are the cabinet, that is the cabinet, and they hold specific portfolios. The ministers there, they hold specific portfolios. They become minister of, say, of railways, they become minister of finance, women and child development, etc., right? Then there is prerogative writs. Do you know what writs are? Under the constitution, we are provided with constitutional remedies under Article 32, right? And under Article 32, we are provided with writs. Can you tell me what are the writs? So there is habeas corpus, there is mandamus, there is certiorari, and there is quo warranto, right? So there are these writs. I would make a separate video discussing the writs, because it is in itself is a very big topic, so I'm not going into the details, but writs comes under the constitutional remedies. That means that in our constitution, we are provided with a judicial backing. If our fundamental rights are violated, we have constitutional remedies, and under those constitutional remedies, we get the writs. All right. There are some parliamentary privileges. When a person is a member of the parliament, okay, then the person have certain rights as they are inside the parliament. Say a MP has some specific privileges when they are inside the parliament. So they have freedom of speech to an extent that is provides them with a privilege that they cannot be charged for what is being said in the house. All right, so that comes under a privilege. There are a lot of privileges that a parliamentarian gets, and this concept of parliamentary privileges comes from the British Constitution. There is bicameralism. What is bicameralism? That essentially means that we have two houses in our parliament, right? So for that we have Lok Sabha and we have Rajya Sabha, right? So that is bicameralism. That means two houses in the parliament, right? Okay, now we are going to the US Constitution. US Constitution, and the most essential thing that we have borrowed from them is the fundamental rights. All right, how many fundamental rights do we have? Can you tell? Do let me know in the comment section. All right, so we have fundamental rights. What are these fundamental rights? How they are different from any other rights that is being provided in the Constitution? Fundamental rights are justiciable. What does that mean? If your fundamental rights are violated, then you can directly approach courts, the Supreme Court, right? So we have fundamental rights that came from the Bill of Rights of US Constitution. Then we have independence of judiciary. No appointment whatsoever is in association of the legislative or the executive of the country. The judiciary, their appointment and their proceedings are independent. They are an independent body. All right, there is the check and balance of power in our country, but despite of that, our judiciary is independent. We have judicial review. If certain acts are being passed by the government and if someone feels like it is violative of the constitutionality of our country, then we have judicial review in which such acts or such provisions or such things can be reviewed by the judiciary of the country. There is impeachment of the president. That impeachment essentially means removal. All right, the process of removal of the president has also been taken from the US Constitution. There is removal of Supreme Court and the High Court judges. That is also a very complicated process. The procedure is taken from the US Constitution. And the post of vice president. All right, the post of vice president is also from the US Constitution. There is Irish Constitution, right? The most essential thing that we have got from them is the directive principles of state policy. What is that? What are the DPSPs? These are essentially guidelines of policy formulation in our country. So these are not rights that are being given, but these are some essential principles. All right, that is like a guiding light towards the policies and the welfare schemes that are to be brought by the government. The nomination of the member of Rajya Sabha, right? The upper house of our parliament, Rajya Sabha. So the members nominated there, the whole procedure of it is taken from the Irish Constitution. We know that the members of Rajya Sabha are not elected but rather nominated, right? They are nominated by the state legislative assemblies, right? So we have members from the state who come together in the Rajya Sabha as the representatives of certain states, right? The process comes from the Irish Constitution. There is also method of election of the president. We know that the president's election is a very complicated process, right? There are multiple layers to it, and this whole procedure comes from the Irish Constitution. Next, we are moving forward to the Canadian Constitution. From Canadian Constitution, we have borrowed the federation with a strong center. So we say that India is a union of states, right? So there are different states in our country, and the states are made as smaller units for better governance of the country. So all the states form together our nation, right? And that in America, what we see is that there are so many states that they have come together and decided upon to stick together. But in India, the process is that India is a country in itself, and it has then forward made the states for better governance of the country. So here in India, the center remains very strong, right? So our federation, we have talked about the federal system, right? That means the division of power from the center to state to the local bodies. So here center remains really strong, and then there are powers in the hands of the state government and the local bodies as well, but we have a tilt towards the center, right? The center is essentially much more powerful than the states. The vesting of residuary powers in center. So I think that you are aware of that there are three lists. Okay, list, that is the central list, there is the state list, and there is also the concurrent list. These lists hold the number of items that comes under the supervision of the specific body. That is, the things that are under the supervision of center, the things that are under the supervision of state, and then under concurrent list there are something where the both center and states have deciding powers, right? But when there is a topic, when there is a subject that is not covered in this list, that center has the residuary power over it, that will automatically be considered to be under the purview of the center, right? Then there is appointment of state governors by the center. So we know that the governor is a person who is appointed by the center, and even though the office of governor, right, the office of governor has come into being from the Government of India Act of 1935, we have to remember that Canadian Constitution have provided for this concept of appointment of state governors by the center. So the governor is like an agent of the central government to keep a check on the proceedings of the state. Then we will look into the advisory jurisdiction of the Supreme Court. Now, what is advisory jurisdiction? Supreme Court not only takes cases that comes to them, but they also have this power in which they can advise the legislative and executive bodies to take certain actions, and such actions are advisory in nature. But as the Supreme Court is a very prime body, of a central body of our Indian polity, this advisory jurisdiction means a lot. Even though it is advisory, it holds a very strong power to influence the ways of the government. Then we will look into the Australian constitutions and the thing we have borrowed from there. There is the concept of concurrent list. The way I said, there is a union list and there is a state list, and they have subjects under them. There is also a concurrent list, that is essentially union plus state. The power of deciding upon such matters is given to both union and state. The freedom of trade, commerce and intercourse. We know that in our country there is a certain freedom of trade and the commerce, and how the whole market is evolving. That freedom is also, that concept is also taken from the Australian Constitution. There is joint sitting of two houses of the Parliament. So when the situation calls for it, when decisions are to be made, then the process and why the joint sitting comes into being, it is a thing that will need detailed discussion, so I'm not going into further details. But when the situation calls for it, we have the provision of two houses of the Parliament. What are the two houses? The Lok Sabha and the Rajya Sabha, right? So the Lok Sabha and the Rajya Sabha comes together for a joint sitting. This provision comes from the Australian constitution. Then there is Weimar Constitution of Germany. What we have taken from there? The suspension of freedom, fundamental rights during emergency. So we learned that there are 3 types of emergency, and when such emergency happens, certain fundamental rights are suspended. Please remember, not all fundamental rights. Article 20 and 21 is still available to the citizens of the country during an emergency, but there are several other fundamental rights that are being taken away during such emergency situations, and this concept comes from Germany, the Weimar Constitution of Germany. Then we have Soviet Constitution, that then was the USSR. When we we borrowed these concepts from them. Now it is Russia. So we have the concept of fundamental duties. We know that USSR used to be a socialist country, right? So they had the concept of fundamental duties. So not only fundamental rights for the citizen, but the citizens had to follow some fundamental duties. So fundamental duties are not justiciable or any in other way, but fundamental duties are like advices provided to the citizens of the country to respect a certain order, to respect a certain philosophy of our country, right? It was not initially part of the constitution, but it came in further with later amendments. It came into being via the 42nd Constitution Amendment Act of 1976. You can write down the date if you want to. Alright. And the concept was taken from the Soviet Union's constitution. The ideal of justice, social, economic and political. Okay, so we made sure that we have justice for all in the aspects of the societal conditions, that is the social justice, there is economic justice, and there is also political justice, and we can see that in our constitution, right? So it is given in our constitution to the justice to be provided on accounts of social, economic and political scenarios. Then we have the French Constitution, and when we think of French, of course we think of the concept of republic because of the French Revolution, right? So the concept of republic itself emerged after the French Revolution, and hence the concept of republic is also taken in India. What is a republic? Republic means that the head of the state isn't essentially hereditary. All right, the head of the state is a elected personality in our country. So this concept of republic, that it will not be hereditary. In a monarchy, it is on basis of heritage, right? One after another, it lives, it goes on from one generation to other of the same hierarchical order. But in republic, the head of the state is being elected. The next concept is the ideals of liberty, equality and fraternity. In our preamble, we have these terms, and these are taken from the French Constitution. Now, South African Constitution. From South African Constitution, we have taken the procedure for amendment of the Constitution. So when we made our Constitution finally came into being on 26th Jan 1950, right? And today it's 2025. So many years have passed by. 75 years have passed by since it have come into being. So obviously there have been some requirements of changes in our constitution, and our constitution is not extremely rigid. It is a mix of both flexible plus rigidity. So we have the provisions of amending the constitution, right? So this process of amending the constitution and adding new things to it, or omitting the things that have gone back, that have become backdated, this provision is taken from the South African Constitution. And the other thing that we have taken from them is the election of the members of Rajya Sabha. So we also saw that, We also saw that here is the nomination of members, right? So the nomination of members in the Rajya Sabha, there are certain nominated members who are from the respective fields, in the experts in certain fields who are being nominated in the Rajya Sabha, and that is taken from the Irish constitution. But the election of the members of Rajya Sabha, right, the members who are from elected from each state and they come into Rajya Sabha, that concept is taken from the South African constitution. And last but not the least, from the Japanese constitution, we have got the procedure established by law. All right, the procedure that is being established, we know that we have Bharatiya Nyaya Sanhita and Bharatiya Nyaya Sanhita and Bharatiya Nagrik Suraksha Sanghita, right? This have essentially the new terms, the new amended installations of the IPC and CRPC, right? So they ensure that the procedure that is being established by the law, that is being carried forward well in the governance of the country, and this concept has come from the procedure established by law. So with that, our discussion of the borrowed feature of the constitution has come to an end. So we have learned that the features that we have taken from the Government of India Act, that is Federal Scheme, Office of Governor, Judiciary, Public Commissions, Emergency Provision and Administrative Details. From British Constitution, we have taken Parliamentary Government, Rule of Law, Legislative Procedure, Single Citizenship, Cabinet System, Prerogative Writs, Parliamentary Privileges and Bicameralism. From US Constitution, we have taken fundamental rights, independence of judiciary, judicial review, impeachment of the president, removal of Supreme Court and High Court judges, and the post of vice president. From Irish Constitution, we have taken the directive principle of state policy, nomination of the member of Rajya Sabha, the method of election of president. From Canadian Constitution, we have taken federation with a strong centre, vesting of residuary powers in the centre, appointment of state governors by the centre, advisory jurisdiction of the Supreme Court. From Australian Constitution, we have taken the concurrent list, the freedom of trade, commerce and intercourse, joint sitting of the two houses of the parliament. From the Weimar Constitution of Germany, we have taken the suspension of fundamental rights during emergency. From the Soviet Constitution of USSR, we have taken fundamental duties and the ideals of justice, social, economic and political in the preamble. From the French Constitution, we have taken the concept of republic and the idea of liberty, equality and fraternity that is provided in our preamble. From the South African Constitution, we have taken the procedure for amendment of the Constitution and the process of election of the Rajya Sabha, of the members of Rajya Sabha. And last but not the least, from the Japanese Constitution, we have taken procedure established by law. So with that, I will end the class. I hope that you learned something new, and as always, the document will be available in the Telegram group. The link is provided in the description of this video. Thank you.